Greetings to all. We are back with new episode of Off the Rest by the Law Culture. Today we have with us Mr. Tariq Khan Sir, who is currently Registrar of International Arbitration and Mediation Center, Hyderabad. He is an arbitration law expert enlisted in the Forbes Legal Powerlist issue 2020-2021. Youngest lawyer listed in Businessworld Legal and 40 under 40 2020 edition. Authored the most celebrated book on the rise and was featured for the same in Fortune 500 Indian edition. Recently, Sir has authored most celebrated book, law, which is a law relating to micro, small, and medium enterprises. And so, to discuss about the same, we are recording today's session. So, sir, moving ahead, my first question would be like, what inspired you to write this book?
Thank you, Animesh, firstly, for inviting me and for having this brief discussion about law relating to micro, small, and medium enterprise. I hope I'm clear and audible.
Yes, sir.
Animesh, okay, great. So, firstly, it's a co-author. I've co-authored the book with Dr. Amit George. And let me give you a brief background how we decided to come up with the publication on the subject. Basically, I had a discussion with Dr. Amit George because I was doing a couple of matters as a practitioner in Delhi and other cities around. And I was appearing extensively in a lot of MSME matters before the facilitation councils in different districts. And then I realized that a lot of people were not aware, and many people, including the officers who were sitting, for conciliation, did not really know the proper procedure. And that's when it occurred to me that, maybe there's a dearth of literature. So Dr. George and I, we were having a discussion about how there is not a lot of clarity on the subject and how there have been no proper amendment to the law. And then we decided to come up with a peer-reviewed journal article which we can get in a peer-reviewed journal, and it can be a co-author where we will try to cover certain areas of the subject. Now, when we started working on this article, we realized that there is actually no literature on the subject. We couldn't really come across any book or any literature which covers the scheme of the act and which gives an introduction about the practice and procedure of the MSMED Act of 2006.
Yes, sir.
And that is the day when we started working and we realized the dearth, and that article turned into a book because we felt that there was a void in the literature and we had to contribute. So we have covered almost every case. There have not been many cases on MSMED Act, but the practice, procedure, the book also deals with the introduction, the history, and how the law has evolved, about the debates, and what was the need to have this act. And we have covered some modern concepts as well. So yeah, that's the short journey of the book.
Great, sir. Since its enactment in 2006, we have witnessed that there is not much literature on MSME Act. So this book will help a lot to the academicians and professionals and all the members of legal fraternity. So moving ahead, sir, MSMEs contribute around 30% to India's GDP, employ about 11 crore people, nearly 40% of total exports, and more than half of them are located in rural India. So, what steps should a government take for welfare of this sector?
See, there are a lot of schemes already in place. The government has been doing good work for a lot of MSMEs, and I see there has been a lot of progress. The erstwhile minister was very, very proactive, and they took a couple of steps, including changing the definition of MSMEs in 2020, if I'm not wrong. In June 2020, they changed the whole landscape. And I think that is something which was a very positive step by the government, because what they had tried to do is they wanted to ensure that abuse of the process should not happen. Because what was happening earlier was that a lot of MSMEs who were registered for a very long time, but they had the turnover had increased over the years, their investment in machinery had increased, but they
Yes.
were still taking the benefits of a micro entity, even though they were not even medium enterprise. So I think this new amendment, which was introduced by virtue of a notification, because
Yes.
central government came up with the notification. That's the only sad part, that notifications are not being included in the act. Otherwise, I think that was a positive step. But one thing I think we can consider doing for the MSMEs is, of course, to increase the awareness about the advantages and benefits which are there for the MSMEs. The
Yes.
biggest challenge which I have seen is that there is no awareness. People don't know about their rights. A lot of MSMEs do not know whether they are MSMEs or not.
Ah, yes.
Second, they don't know what are the benefits for the MSMEs. Third, they don't know how to avail these benefits. And fourth, they don't know the dispute resolution mechanism under the Act. They are filing cases in civil court because the MSMED Act gives a lot of privileges. It's a welfare legislation, but ultimately the parties really do not know how to make use of it. So I think that's another challenge which parties face. So maybe the government should consider, firstly, to come up with a legislation just like they did with arbitration. An amendment act has to be introduced so that even judges, lawyers are also getting clarity. Right now, what happens is, if we have to refer to the provisions of the act, we will look at the 2006 act, and now there have been various changes in the law by virtue of these notifications, which are nowhere to be found, including that issue pertaining to whether the definition of a supplier would also mean a person who was not registered under the act. That issue was there for a very long time.
Yes.
But all I'm saying is that just like in Arbitration Act 1996, we came up with an amendment of 2015 to remove the difficulties from the act. I think similar amendment needs to be included or incorporated, and it is something which is a priority because it is affecting lives of many.
Yes, sir.
And these MSMEs, if they don't get the advantage, if there is no awareness and they don't know the dispute resolution mechanism for recovery of their invoices, then ultimately they will become sick industries and they have a very small budget to function on. They don't have a lot of investment. So I think that's one thing central government can do, to carry out programs, to train the officers who are dealing with such cases, then to bring a legislation, which is an amendment act to 2006 act. And then thirdly, there can be awareness programs where people really know what are the benefits and where to make use of that. I think these are a few suggestions which I'd give.
Indeed, sir. Indeed. And sir, the Section 18 of MSME Act basically talks about the facilitation councils to settle disputes. And so, how can facilitation councils be made more effective?
That's a very pertinent question. I think they need to be trained. Like I said, training is very important because in my experience, I have practiced as a lawyer in MSME cases in various states. More than 6 to 7 states I have appeared. What I have seen is that the persons on the conciliation board themselves are not very clear on the law. And it is not their fault because there are a lot of conflicting decisions. The language, if you will see, the procedure, the law has not evolved as such. Therefore, there's a lot of scope for confusion. And they don't know the procedure, especially the conflict with the Arbitration Act.
Yeah.
They don't know whether they should refer to provisions of Arbitration Act or whether they should finish the conciliation in 90 days or it will be 1 year. Another issue can be in relation to, if you look at the language of the Act, it says that every reference. Now, reference would mean what you are filing in the conciliation or what you file for arbitration. Another issue is whether what you file at the stage of conciliation, there's a format that they have in an affidavit format. They sometimes treat the same thing as a claim also. So you don't really get an opportunity to change the contents. Plus, conciliator sits as an arbitrator in some of the councils. That's another issue which is going on. So whether conciliator himself or herself can act as an arbitrator. Another challenge, obviously, is that they don't know whether they should be sending it to an independent institution. Because when they do that, like in Delhi, they used to send it to DIAC, the Conciliation Board. And Delhi International Arbitration Center would appoint an arbitrator. who would again then treat it as a proper arbitration started under the Arbitration Act, and the matter would go on for more than a year and a half. So I think these are few things on which we need clarity, and I think training clarity in the law, sloppy drafting of the law should be avoided, and I think we need to train our facilitation councils, which because it will be in the interest of the uh, or maybe we can have some special courts only to deal with such cases and specialized young lawyers or young judges who can look into these cases.
Correct, sir. And sir, there seems to be sometimes the conflict between the MSME and the Arbitration and Conciliation Act. Now, having said so, the Supreme Court recently passed the Shilpi Industries judgment. So, what's your view on that judgment?
So I had written an article criticizing the judgment, and I was not very happy. With great respect to the Honorable Supreme Court, I think the reasoning was not in line with the object of the Act of 2006. Firstly, for the very simple reason that while dealing with the issue as to whether counterclaims were within limitation, the court made it clear that since the judgment of the High Court was an order of remand, it will not get into that controversy, and thus kept it open for the primary authority to go into this issue and record its own finding on merits. However, on the other hand, the Supreme Court delved into the merits of the case and held there is no acceptable material to show that supply of goods has taken place or services were rendered subsequent to registration of the appellant as the unit. So it is required to be noted that appellant in that matter had claimed to raise last invoice after having approached the district industrial center for grant of an entrepreneur memorandum. So I think the court ordinarily should not have got into the merits of the case because it was not the appropriate stage, and the purpose of MSMED Act should have been considered. That the purpose is speedy disposal of cases, which is clear from the language also. And it says that, under such cases, it should be done within 90 days. Section 18.5 clearly says so. And in fact, the court in that judgment has emphasized a lot on the benefits under the MSMED Act, that is the welfare legislation, and that there are various benefits. Now, various judgments have been passed by the various high courts. But Supreme Court, most important, the biggest problem is that the memorandum, there was a notification by the government of 2007, which was not brought to the notice of the Supreme Court. And this was a notification dated August 1st, 2007. Okay. And in that, it was clearly mentioned that it is voluntary for the enterprise to file the memorandum as and when it decides to do so, which means that the government had clarified that registration is not mandatory to avail the benefits under the Act. However, this memorandum was not, or this, this notification was not presented before the Supreme Court by either side. And that is the problem why, I feel that the scheme of the Act has been diluted. And I personally feel that if it's a welfare legislation, we have to harmonize with the intention of the Act, and we have to see what is the whole purpose, and we have to extend the benefit. We have to ensure that the benefit of the Act is inclusive rather than narrowing it down by saying that unregistered entities will not be covered as MSMEs and will not get the benefit of the Act. So, I mean, there are various other problems which I found with the judgment, but of course, with great respect to Supreme Court, I think that the judgment really dilutes the effect of the Act. And there are other judgments of the High Court. If you look at the judgment in Ramki Industries by Justice Bhakru, the Delhi High Court judgment, I think that was an excellent judgment. You look at it, how Justice Bhakru has explained, and there's also another judgment by Justice Murlidhar, GTND versus Reliable Engineering. Both these judgments were doing pretty well. In fact, the Ramki judgment did clear the controversy about unregistered suppliers, whether they will get the benefit under the Act or not. But we'll have to see till when Shilpi Industries is going to be good law, because I think, in my view, it should be referred to a larger bench, because I personally feel that the correctness of the judgment may be questioned, and because there are a couple of things which are not brought to the notice of the Honorable Supreme Court.
Correct, sir. So thanks a lot, sir, for accepting our invitation for this session, and it's always grateful to interact with you. And to interact with you, we get some good insights on arbitration and uh, the MSMEs and uh, various fields of law. So, by writing this book, you have done a great contribution for the members of legal fraternity. As I mentioned before, also that there is not much law, there is not much literature on law relating to MSMEs. So, by writing this book, you have contributed a lot. And so, we would like your concluding remarks of the session.
Thank you very much, Animesh. Once again, it was lovely talking to you again, and it's always a pleasure to speak on topics where there is a dearth of literature. To tell my friends, and whoever is watching, the participants. I just want to say that MSME is a sector which is upcoming and which is now increasing, and we see a lot of disputes coming up. So it is a great area to practice, especially for the younger lawyers. And this way, I think we can also give back to the society by helping the micro, small, or medium enterprises. So it's a great field to be. I think specializing in this field can do wonders for young lawyers in their practice as well. And I think we need young lawyers like you also to take part in it, to actively read upon it, to help the jurisprudence evolve, and so that we have something to in times to come. We will see a lot of work is increasing, and there'll be offices which will be only doing MSME matters. So that's my take on the subject, and I hope that we see young lawyers taking it up as a career choice also.
Thanks a lot for accepting our invitation and sparing out time from your hectic schedule, sir.